Next matter to come before the court this morning is Susan Lloyd versus Justin Rogerson. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time for rebuttal, let me know when you get started. I'm keeping the clock and can let you know when you're getting close to or into that reserved rebuttal time. Please don't use the names of any victims or minors in this case, as we are live streaming this oral argument and posting a recorded version on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
Okay, yes, I would like to reserve 5 minutes at the end.
Sure.
As you're aware, on June 28th, 2019, this case was remanded back to trial from the appeals court for further proceedings. Since that time, not a single other thing has happened. There has been no other hearings held, absolutely nothing whatsoever. On March 2nd, 2020, Rogerson filed another motion for summary judgment without conducting any further discovery or any hearings taken place since the appeals court remand. On March 16th of 2020, I found a motion to strike his motion for summary and a brief in opposition. On March 18th, Judge Wiest gave me until April 10th to supplement my brief. And on April 2nd, even before the April 10th deadline, he dismissed the case once again with prejudice without any further hearings being held. Rogerson, as you remember, signed a smoke-free lease only to smoke cigarettes and acknowledged through his testimony in November of 2014 that he was causing me harm. He admitted to smoking in a smoke-free community for up to 15 minutes at a time, even after knowing he was injuring me. He verbally threatened me to the point where the district attorney Lutz had to get involved and send him a letter telling him that he will go to jail for 6 months if he does not stop his actions towards me. Then and only then did Redwood Living move him to their other complex in Wooster, Ohio. Redwood Living in November of 2015 settled with me for their part in my damages. So 6 years ago, Redwood Living settled with me. Rogerson turned my claims against him into his insurance company, USAA, who then hired Mr. Keneally to represent him. Instead of Rogerson doing the proper thing and settling against me and settling the case, he has decided to go on a 7+ year rant and tirade against me. There has even been testimony in a Portage County case, 2016-00230, which I'm involved in, where Joshua Thornsberry admits to contacting Justin Rogerson, and they both corroborated to not only derail the cases that they're involved in, but to derail all of my other cases that were pending in the state of Ohio. This shows Rogerson's malicious and purposeful activity towards me. Rogerson was aware since 2014 of all of my evidence. Rogerson continues to state in his briefs that the cigarette smoke penetrated the walls, which is simply not true. He has a copy of the builder on tape, along with this court, stating that the vents and the ductwork are connected and the outlets, and that's how Rogerson's cigarette smoke went from his apartment into mine. Rogerson has made up one lie after another about me. His only evidence that he gave to my previous attorney, Hall, is a videotape where he's actually wiretapping me as I'm having a private conversation in my own apartment, telling a friend of mine that Rogerson is making me sick from smoking his cigarettes. Rogerson has known since the day I moved into my apartment in July of 2014 that he was causing me harm. He became so belligerent towards me that day, I had no choice but to call the police on him. Rogerson also filed a motion for sanctions against me, which is just a frivolous motion, along with his motion for summary judgment. I believe that I should be warranted sanctions against Rogerson and his attorney because there's absolutely no good faith argument, no modification or reversal of existing law, and no establishment of new law that can possibly show that his motion for summary judgment was filed simply to harass, cause unnecessary delay, and increase the cost of this litigation. This litigation has been going on since, well, officially 2014 is when Rogerson knew he was going to be sued in court. And I think it was officially filed in 2016. And like I said, Rogerson admits to every single thing that I've ever accused him of with his own testimony. Rogerson's also been aware that there's 3 doctors who supported my injuries that Rogerson was causing me and my service dogs. Rogerson and Keneally are clearly abusing the legal system by trying to take a second bite of the apple, so to speak, by filing yet another motion for summary judgment without any further further hearings in this case. This is a direct violation of the appeals court's previous remand back to the trial court. And the Wayne County Court has been protecting Rogerson since the case was filed. They even put a permanent seal on his psychiatric records when Attorney Hall attempted to get them. Rogerson came to court dressed in his Army uniform in November of 2014 and made up one lie after another about me, even stating that him and his wife are afraid of me. When Rogerson was later questioned this, he states he was not afraid of me. Rogerson took an oath as a U.S. Army sergeant to protect U.S. citizens, and all he has done since 2014 is maliciously and knowingly cause me harm. His filing of yet another frivolous motion for summary judgment is just another way for him to abuse the court system. In Ohio, a pro se party may be awarded attorney's fees and costs when defending a frivolous motion. Elsa's versus Frank, 2002, Ohio, 2947. Like I said, this case has been going on now for 7 years. It was officially filed in 2016, but Rogerson knew of the injuries he was causing me since 2014. Attorney Hall attempted to settle this out of court in 2014 by sending him 2015 by sending him a demand letter, which he never responded to. It's been like I said, Rogerson already admitted to his harm. Not only that, but then he sat there and he joined forces with Joshua Thornsberry in Portage County to maliciously and purposefully injure me further.
Miss Lloyd, I wanted to ask you a question. I want to make sure we're all on the same page. You keep talking about injuring you. I thought the remand to the trial court from the original appeal was in regard only to your personal property.
Well, it was. Of course, I still disagree with that. I mean, like I said, there's already been testimony that he injured me. Obviously, if he's injuring me, he obviously injured my property also. I had to throw away my furniture, which was brand new. I've already submitted receipts with that to the court. He injured my service dogs. There's letters from my vet showing that I took my service dogs down there and they were reeking of cigarette smoke from being inside of my own unit. There is the builder is on tape stating that the cigarette smoke entered through the vents and the outlets because they were connected to each other. And once again, this was a smoke-free community. So Rogerson signed a smoke-free lease only to sit there and continuously smoke cigarettes inside of his unit and directly next to my unit after knowing that he was causing me harm. He knew from the day I moved in there, he was causing me harm. Like I said, when I asked him not to smoke next to me, the day I was moving in, he was actually smoking in my driveway. When I pulled up with my moving truck, I approached him and I told him that I have a heart problem. I'm extremely sensitive to cigarette smoke. This is a smoke-free community and please don't smoke by me. He went on such a tirade rampage that I ended up calling the police on him. So, like I said, it got to the point where he continued his abuse towards me to the point where he was sent a letter by the district attorney Lutz saying that he can go to jail for 6 months if his behavior towards me does not stop. So it's obvious if he smoked so much to actually cause me asthma, which I still suffer from today because of him, that of course my furniture and my service dogs are going to be injured as a direct result of Mr. Rogerson. And Mr. Rogerson was my only direct neighbor because I had an N unit. So he can't sit there and blame the ones next to me. And like I said, he already admitted to this in court. I don't understand what his issue is, that he just won't settle this case. Instead, he's dragging me through the court system for 7+ years. And then, like I said, in November of 2014, he showed up in court with his Army uniform and made up one malicious lie after another about me, even stating that I looked into his windows, I videotaped into his windows. None of that was ever true. He sat there and maliciously defamed me in a court of law. And now he joins forces with other people to still injure me 7 years later. I don't understand what the guy's problem is. I mean, he sat there and took an oath to protect U.S. citizens just to sit there and purposely, maliciously injure a disabled one. And
Ms. Lloyd,
yes.
Ms. Lloyd, I need to let you know that you are reaching that rebuttal time. You've reserved 5 minutes. You may continue, or you may reserve it as you wish. I just need to let you know that you're there at that point.
No, I want the 5 minutes.
Okay. Counsel for the appellee.
Thank you, Your Honors. If it please the court, my name is Christopher Corrigan. I do represent Justin Rogerson. Justin Rogerson is a highly decorated U.S. Army sergeant who has served honorably in the United States and is being put through a very tragic situation having to deal with this case. I would only start with the fact that the things that Ms. Lloyd have said are just terrible, and we had filed a motion to strike the things that she had put in her brief that was denied by the magistrate. We feel terrible because some of the things that she said in that brief were just so terrible. If they weren't put into a brief, they really should have been part of a defamation case. And the only reason that there's not is because there's probably nothing to come to go after for what she has done to him and continues to do to him in this matter. I'm going to try to limit to what the issues are. What the issues are raised here are found in the assignment of errors, as I've mentioned in the brief in this case. The first one has to do with the remanding of the case for further proceedings, and further proceedings did take place. Now, whether or not Ms. Lloyd likes that is not, as to how the further proceedings were conducted is not in her realm. It's basically the court did set up further scheduling, set a trial date, set a date for motion for summary judgment. The motion for summary, she did not object to a motion for summary judgment deadline. She did not object to any of the dates that were put forward by the court.
And counsel, you're talking, counsel, I'm sorry, you're talking now about when it was remanded originally from this court.
Right, for further proceedings, correct. And as you said earlier, it was remanded on the issue of property damage. She has gone on extensively about her physical injuries. That has been decided, and that's not an issue here. So there were further proceedings there. Just because we did not do discovery, we looked at the case. We said there's nothing here to establish a proximate cause as to any infiltration into the apartment. There's nothing to support that. We then go on to the fact that the court, she was given several opportunities after the motion was filed, in this case remanded for the ruling on the 60B motion. She never stated the precise 60B area that she was going through, 1 through 5, but the court did grant her the 60B, allowed her 2 separate times, both in August and November, to supplement her brief in opposition to the motion for summary judgment. She could not provide any Civil Rule 56 evidence, but at the end of the day, that's not even an issue. The motion for summary judgment is not an issue. That's not one of the assignments of error here. The 3 assignments of error have to do with the proceedings, and that's basically there were further proceedings both before the motion for summary judgment and after the motion for summary judgment were filed. So there were the further proceedings. The court did its rulings. These are how litigation works. It's up to the litigators whether or not they want to if they want to do further discovery or not. That's litigation tactics.
Counsel, could I interrupt you again? I want to make sure I understand the procedure that happened here. So it was remanded for further proceedings, as you were talking about, and then a summary judgment ruling was granted on behalf of your client. And then Ms. Lloyd appealed that and filed a 60B. And the 60B, we remanded back for the 60B to be ruled on, correct?
Correct.
Okay, and then when the court ruled on the 60B, the court granted the 60B. And what did the court do after it granted the 60B?
It gave her the opportunity to file a response to the motion for summary judgment and supplement any evidence to support the issue of proximate cause regarding property damage. It gave her two separate dates. August 15th is the one date, and the second date was in November, and I'm blanking as the second date. But so it gave her originally, I believe, in July till August 15th. Then on August 15th, it issued another order saying, well, we're going to give her until November. I'm trying to remember the date in November, but to give her November to provide any supplemental evidence to support the issue of proximate cause. And then it was not until January that it finally made a ruling. She never filed anything that would support the issue of proximate cause. And even though she's a pro se, she was given ample opportunity. She has to be treated as a regular person. Whether or not an attorney or pro se is all the same. She did not provide any evidence supporting that would support a reply. There's no evidence in response to that. So there were further proceedings, both as the timeline provided for once it was remanded back and the court set its schedule, and then she was given months afterwards after the court did actually grant her Civil Rule 60B motion.
So wouldn't that make sin of error number 3 moot? I mean, the court ruled on the 60B and it granted the motion.
And that is our argument, is that the third assignment of error is moot because it did grant the 60B. Okay. I completely agree with that, Your Honor. The second, so there were further proceedings. Whether or not, the fact that they're not full-blown hearings is not really it's not an issue. That's not what technically ever happens in civil litigation. I mean, I've always laughed that even when you look at the civil rules, the term hearing doesn't always mean hearing. It just means that basically there's going to be a ruling at some point. So we use the word procedure, but basically means that there's got to be some type of things that happened in the case. The parties be given the opportunities normally attenuated with the civil rule, with the rules of civil procedure, which is what happened. The parties were provided the opportunity to do further discovery if they wanted to. They were given times for deadlines. The trial date was scheduled, and that's what happened. And there was no problem with that until the motion for summary judgment was filed.
Counsel, I want to make sure too, again, so with the procedure again, so after the 60B was granted, she was given additional time to present evidence, and you said that no evidence was presented, and the court ruled on the summary judgment motion again?
Yes.
And granted the summary judgment motion in favor of your client again?
Yes. So as I'm looking, it was August 15th was the initial date, and the judgment entry on that was July 23rd. He gave her until August 15th. Then on August 15th, he entered another judgment entry saying that she will have then until November 15th to supplement the record with any 56C, any 56C evidence. That never happened.
Okay, I just need to make sure, because I haven't had access to the docket yet. So I want to make sure too, and obviously we'll give Ms. Lloyd an opportunity to respond to any of this. But so was there any amendment of appeal or anything?
No.
Thank you.
Yeah, so there's been ample proceedings. There was and as it was mentioned, the 60B motion, the error on that is moot now because he did grant it and provided her ample opportunity to supplement, which she did not provide any 56C evidence. And then going to this reversible error, or a reversible error as to motions for sanctions, as we have said, that this seems to be a far-fetched motion, because clearly there is no evidence of proximate cause. She keeps saying that there's these audio tapes. I have no idea where these are, who these voice, if there are these audio tapes, whose voices are on these audio tapes. Nothing is, as we say, is certified pursuant to Civil Rule 56C. So at the end of the day, I don't even know what she's talking about when it comes to something that he admitted to injuring her. He's never admitted to injuring her. This is absolutely absurd. There's nothing in the record as to what she's talking about. She then talks about other cases. I can't tell you what was said in another case, obviously. There's no evidence that comports with 56C in the record. I don't know of any of these audio tapes that she's talking about, but regardless, the issue it comes down to is this smoke that's not in her apartment, and that I think is in the deposition records. It's, there's no evidence that he ever entered into her apartment. She would never let him come close to her apartment, which is fine. I don't think he would want to, but most importantly, in essence, this is his cigarette smoke. There's no evidence that could have been the proximate cause, because there's nothing that says that it permeated into her walls. I mean, truthfully, she talks about supposedly this recording that the ducts are all connected. Well, but you're going to tell me that smoke will take a left turn here, a right turn over there, go up the steps, that, over this way. This is bizarre, and then somehow comes into her apartment and then goes down, or I'm not even sure how the ductwork works in her apartment, in the old apartment, but then gets to her dogs or whatever, or to her furniture, because she's making the claim about her dogs and her furniture. There has to be some type of expert testimony or expert support that this smoke somehow basically the evidence really only shows that he was smoking outside. She's going to say that there's some type of evidence that she smoked inside, but I don't even know how that could even occur. But there's no evidence that he actually smoked inside. Every time that everything in the record basically indicates that when he would smoke, he would go outside to smoke. How that somehow gets into her apartment is beyond my knowledge, and I would put it that it's well beyond the ken of any jury as to how it could infiltrate an apartment. It almost reminds me of the cartoons where the smoke kind of all of a sudden is going this way and going that way, and just going for the one particular location. So,
well, was there an affidavit? Excuse me, was there an affidavit from the builder concerning the two rooms being connected via the vents, or testimony?
No, there's nothing in the record as to that. And so,
okay.
I don't want to go down this road too far, because I'm kind of going too far off the path to establish the fact that what we did was the proper thing. It was a motion for summary judgment. She's saying that we should be sanctioned for filing a motion for summary judgment. That's the issue error. So basically, we have three errors. One, that the trial court committed error by not having further proceedings when it did clearly have further proceedings. We filed a motion for summary judgment that is connected with those proceedings, and she's saying that we should be sanctioned for having done our job and having properly represented Mr. Rogerson. That any reasonable attorney would have filed the motion for summary judgment, and that's exactly what happened here. So her second assignment of error should not be well taken. It should be denied outright. And then, as Judge Teodosio even mentioned, when we get to the third assignment of error, which is the ruling on the 60B motion, that is moot. So that is where we are today, and so that should be denied as it is moot. And I don't think there's anything for this court further to do but to basically affirm the Common Pleas Court for properly doing proceedings. And there was no reason to grant a motion for sanctions. I don't think this court, if the lower court had granted us the motion for sanctions, I think this court would have had to have said that that was an abuse of discretion, because any reasonable attorney would have filed that motion for summary judgment. And as we said, the 60B motion is moot. So we would ask that you affirm the Wayne County Court of Common Pleas and on its rulings. We thank you for your time here today.
Thank you.
Yeah.
Ms. Lloyd, you have 5 minutes remaining. You will need to unmute your microphone, and we actually cannot see your face at the moment, but there you go.
I realize that. I was looking through the docket so I can go back and dispute what he just said. So basically on August 15th of 2020, I filed an affidavit of supplementation. I mean, I don't see any reason why I need to keep filing documents and videos over and over and over again when all of this was already filed with the court several years ago. And so I filed an affidavit of supplementation, which clearly shows all the evidence that I have for my claims, all the evidence that Mr. Rogerson has had since 2014, really, but at least 2016 when this case was officially filed. And another thing, on October 5th of 2020, October 15th of 2020, Judge Weiss granted relief from judgment and then states yet again he will decide the motion for summary judgment, which again, no hearings, no other evidence was given. He just automatically granted it yet again. The same evidence that, again, Mr. Rogerson never conducted discovery, okay? Everything that he has in his possession, we gave him with the first appeal. Mr. Hall did. And another thing, if Hall, Attorney Hall, if he's the one that messed up and I needed an affidavit from the builder, it's already been determined in Ohio that a case cannot be dismissed based on the errors of an attorney. So, and no discovery deadline for this case was ever set. There was no expert deadline ever set, nothing. I brought that up in the first appeal in terms of my medical doctors who were willing to testify on my behalf. And yet it was that part of the case was dismissed anyway, even though no discovery deadline was ever set in this case. His other claims for Rogerson are laughable, to be quite frank, that he's a highly decorated U.S. Army sergeant, and it's a tragic situation for Rogerson. Excuse me, but Rogerson is the one who moved into a smoke-free community just to smoke cigarettes, who his own testimony already admits to him causing me injury. So the only tragic situation about any of this is the fact that he has been dragging me through the mud and defaming me now for 7 years in a lawsuit. 7 years this has been going on. I mean, the Redwood Living settled with me in 2015, 5 years ago, 6 years ago now, actually. And yet Rogerson is still dragging me through the mud. In terms of me reporting him to Wayne County Child Protection Services, that's true. These walls were extremely thin, and I literally heard him smack his child was like 2 years old at the time, through the wall. His kid would be crying. He would smack him and then start screaming bloody murder.
You still have 2.5 minutes remaining, but I want to focus in on those assignments of error that we have in front of us with respect to the evidence of property damage. Your supplement, which was filed in August of 2020, did it have it? We have not seen the docket yet, but did it have anything attached, or did it refer to evidence that was already with the trial court?
If you can give me a second to.
Well, we can find it. I just wondered if you were aware of it. Unfortunately, we lost contact with you visually, but. There
Is
we
that
go.
better?
Yes, thank you. I mean,
must
it's
have bumped
it's
something.
okay. I just, the court's very concerned and wants to make sure we have the assignments of error that are in front of us properly decided. And we can look at the docket for sure, but if you knew of what was in evidence, we've heard from both sides now that there is evidence and that there is not any evidence. So I was trying to clear that up.
And there's absolutely evidence already submitted with the court.
Okay, thank you. You still have about a minute and a half remaining.
So once again, Mr. Rogerson has already admitted to fault through his own testimony in 2014. The video of the builder clearly states as the smoke entered through the vents and the outlets, whether or not he wants to believe it or not, if something is connected and he's chain smoking cigarettes for up to 15 minutes at a time, his own testimony, in a smoke-free community, where does he think it's going to go? In terms of him saying that it should be sealed, the record should be sealed, I'm defaming him. For one thing, the First Amendment right is a First Amendment right to publish truthful information in regards to a case, 2010 Ohio 1533. It's a public's right to have the information for a trial. Injury or potential injury to a reputation is not enough to deny public access to a court document. I mean, Mr. Rogerson just does not want to accept the fact that he took an oath to protect a U.S. citizen. He knew he was injuring me per his own words. And then 7 years later, he still refuses to take responsibility for the actions. And then he joins forces with other people to maliciously and purposefully injure me further. So in terms of that, this case should once again be remanded to the trial court. At this point, Judge Weiss should be recused from the case because he obviously is showing prejudice and bias towards me once again. He has all the facts of the case. He just also refuses to acknowledge it because he is protecting Mr. Rogerson at all costs.
Ms. Lloyd, thank you very much for your presentation today. I allowed each side a little extra time because of technical difficulties and questioning. The court will take the matter into advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next video oral argument date is Thursday, October 7th. We are adjourned. Have a wonderful day, everyone. Thank you very much.
Thank you.
Yeah.